Jessica Rooks. I'm with the Rooks Law Firm. And I'm going to tell you, if you like fill out this form and you do this, like there are like gradients of excellence. Like that is like the gold star supreme level, like go you. Like that is awesome. This reminds me when I was hearing that, I don't know if you've ever heard of the comedian Nate Bargatze, but he was telling a joke and he said, he's like, I got a call from the school one day and they told me that my daughter wasn't feeling well and I should come get her. And I said, did you reach out to her mother? And they said, no, we had two parents on the list and we chose you. He's like, you had two parents and you thought, yeah, dad's the one to handle this call. He's like, I don't even know what school she goes to. I'll come do it, but what school am I going to? And so I joke, like my husband is like the go-to pickup person for the kids. But that's the reason why the form is actually really helpful. You might be thinking, I'm putting this down for stranger to let them know where the school is. No, it is actually for your significant other to know what school to go to and what teacher is there. Because if they're in panic mode, that information isn't going to be readily available. So this is awesome. I encourage you, if you're able to get the time to do it, work on it. This is great. Because when you are in crisis, it's going to be harder to find those things. So wonderful resource. Today, though, I'm going to assume that you are going to be like 90% of the population, and I'm going to assume you've done nothing. And if that's the case, that's kind of where we're going to talk about. We're going to talk about the basics of estate planning. And this is an area that I say is full of coffee talk. And coffee talk is where everybody's kind of had some experience with these things, and they talk about it, and then that's how they shape their interpretation of what the law is. And unfortunately, that tends to be significantly different than the reality of the law. So we're going to talk a little bit. Let me go back to the beginning, and I'm going to tell you a little bit about myself. I'm in Kirksville. I have the Rooks Law Firm, and I only do two things in it. I do estate planning, and I do long-term care planning. And that's it. And I do those things very well. But if you said, hey, Jessica, can you do a speeding ticket? The answer is no, very poorly, and won't even touch it. So I don't do anything but these things. In Kirksville, I am married. My husband's name is Aaron. I have 3 kids. Dylan is 12, Ryan is 10, Libby is my little girl, she's 7, and my mother also lives in Kirksville with us. Okay, so you have a little bit of a landscape of my life. Let's pretend that I am like a majority of people in society and I've done nothing and no planning, and something happens to me right here and I have a stroke. I've told you a little bit about my life, and I have to go to the hospital. I can't make decisions for myself anymore. And I didn't do paperwork because, man, I'm the worst estate planning attorney ever. And I didn't do my own paperwork. So I have no paperwork and I've had a stroke. I can't make medical decisions for myself anymore. Who's going to make those decisions? And if you're a brave soul and you're like, I want to talk, you may raise your hand if you think you know the answer. And that's okay. Oh, okay, let's do it. No, if I were in California, it would be Aaron. And most people think, well, it's Aaron. Like, we've been married like over 20 years. Like, didn't he get the right to say, yes, give her a vaccine? Don't give her that flu shot. Yes, you may withhold food and water. Like, did he get that right in marriage? Like, you would think the answer would be yes. No, not in Missouri. He has no rights to decide what happens to me. So who is it? Is it my mom? Nope, not my mom. Is it my minor children? Nope, not my minor children. It's absolutely no one. Guess who it is? It's the Adair County probate judge. That's who's making the decision. And so here I am just having a stroke. My kids don't have their mom fully functioning. My husband's in crisis mode. Do you know what he has to do now? He has to go down to the probate court and he has to file a petition and ask to be the person to make the decision of what type of treatment I get. Do you know what he doesn't need? That. Because that's a huge thing. So what is it that we can do to make that not happen? That's a power of attorney. That is the simplest, most beautiful document any human will ever create. But they're not all created the same. So I see documents because, again, I do long-term care nursing home planning. That's a large portion of what I do. I see all sorts of documents, and they're not all constructed the same way. Almost all of them will allow for basic things, such as the bills to get paid. But there are a lot more complex decisions that have to happen that power of attorneys may not address. And we'll go a little bit into that as we kind of progress in today's topic. But we're going to start with going over what is a power of attorney. So we're going to get to know, we now know it's important, and we probably know we don't have one, or we're questioning whether we have the right one. So there are two types that we have. We have a healthcare power of attorney, and we have a financial power of attorney. We're going to start with the healthcare. The healthcare is broke down into two categories. There is an advance directive, living will, that's what you've maybe heard, and then there is a healthcare power of attorney. The advance directive and living will is what I would consider like an optional document. Not every person needs it. It depends on the circumstance. What that document says is, if I'm in an end-of-life situation, do not do, and then it's a whole list of things. Don't give me food and water. Don't do this. Don't do that. Don't do that. I've made that decision. Jessica has made that decision before any medical event has happened. I personally don't actually have an advance directive. I do have part two. I have a power of attorney for healthcare. When I went in and had my children, I had C-sections, and so I knew there was a possibility I wasn't going to be able to make decisions for myself, and I wanted my husband to be able to make those decisions, but I wanted him to have flexibility because I'm younger, to look at that scenario and say, you know what, yeah, let's do some food and water for a couple weeks. Let's see how that goes. If we had an advance directive, that's not his decision. That was my decision. And I said, don't do that. That's why I put it down there. Now, let's put it down the road, and now I'm 40 years older, and I have cancer, and I'm going to be passing away. I may make those decisions because now I want that burden of that really hard call off the shoulders of my spouse. So yes, it's a great document, but it's not a great document for every person in every situation. So it's really important to know what you want and what your agent, the person that you're choosing to make decisions, what they are capable of handling and what they want to handle. That's a big decision. And I talked to Aaron about it. I'm like, okay, like, are you prepared for this? And I also had to be comfortable with the fact that he may never want to let me go, and I may stay in that state for longer than what I would want. But ultimately, I said, you know what? I'm going to let you make that call. In my thought process here, I'm not able to make that decision. You can go ahead and do it. But again, advance directives have their purpose just in certain circumstances. So it's just good to know what that document is. So advance directive, that exists. If no advance directive exists, then we have decisions made by the durable power of attorney for healthcare. Now, the advance directive was only dealing with end-of-life choices. It's like you're not talking, you're comatose, and we're talking about treatments. There's so many other decisions that need to be made, and that's what that durable power of attorney for healthcare does. So, advance directive you may or may not have, but the important document is the durable power of attorney for healthcare. And this one is where you're going to choose somebody. Okay, state of Missouri requires these to only happen when you're incapacitated. That makes logical sense. You know, my spouse is my power of attorney. We both sit down at the doctor, and doctor says, would you like the blue pill or the red pill? And I said, I would like the red pill. And he says, give her the blue pill. Well, we're taking the red pill. Like, it's actually my call. He's my agent, but it's me. And that makes sense for healthcare decisions. It's only effective when a doctor puts into writing, Jessica is not capable of making healthcare decisions. If your document doesn't say, 2 doctors is the default under law. Let me tell you, when you're in a crisis situation, finding 2 primary physicians to sign off on capacity is really hard. I generally don't recommend it. I recommend 1 physician because it's hard enough to get on a doctor's schedule to get them to get you your letter so that document can become functioning. Making that even harder is a bad idea. So, power of attorney for healthcare, you choose your person. It could be spouse, it could be a friend, it's somebody who's really good under pressure. This might be your nurse in the family. This is somebody who can get things going and take you to appointments and be with you. That's the right person for the power of attorney. And this is going to be, if you have dementia, this could be a document that's functioning for a decade. And this is the document that's going to let them decide, where do you live? Do you get a shot? Do you get a vaccine? What is it that's going to happen to you? That healthcare power of attorney, when you don't have capacity, that's the person. It's also going to say who is in charge of your burial. Now, Missouri law does not have a default of who should make healthcare decisions for you, but we do have a default who should make funeral arrangement decisions for you. So I love in law school, it stuck with me. So this was like over a decade ago. We were talking to the funeral director of Missouri, and he was talking about the worst scenario he'd ever seen. And it was a gentleman passed away, and he had had a one-night stand, and he'd had a child, and did not treat that one-night stand very well during life, supposedly. And so he didn't have there was like, okay, he passed away, and the question was, who's going to run the funeral? Okay, well, there was no power of attorney document, so we go to the default law, and it says his child. Okay, well, his child's like 12, so that means the guardian of his child is making the funeral arrangements, and she doesn't like him very much. He said it was the worst stick it to someone she'd ever seen, because he didn't have a document specifying who's actually in control of that decision-making process. And so it went under the default provisions. And when the state tries to guess, sometimes it gets it, and sometimes it doesn't. And so I like you to make that call in your own documents. It's not hard, but it means the document needs to exist. Okay, so that's where we say what kind of funeral preferences we want. That's where we talk about our organ donations. Whenever you go to the doctor and they're like, hey, do you have an advance directive? Like, that's what they're talking about. That's what they want on file. And so that's kind of step one. I talk real fast. And I talk a lot. I'm going to pause, and I'm going to see if you guys have any questions, because I love questions. And I'm also going to get a drink of water. So it'll be a combo. Any questions? So this is what a healthcare power of attorney is. Any questions about what it is? Yeah. Oh, okay. Yes, one of the worst things you can do is make your own documents. The law is about as foolish as it comes to not doing common sense. Oh, okay. I love that you brought that up. In my healthcare power of attorney documents, I have a provision that says, if I'm dead, I'm incapacitated. Right? That sounds pretty straightforward. There's a Supreme Court case that came down in 2014 arguing over this exact point. The question was, they said, if the power of attorney comes into effect, I'm the person who decides who the body is, gets to what happens to the body, and then if it doesn't come in effect, then I'm the person who gets to argue it. And person over here said, well, this document says if you're incapacitated, I get to do it. And they're like, right, but a doctor never said he was incapacitated. And the other person said, right, but they're dead, so they're obviously incapacitated. And the court said, no, we agree over here. Death does not mean incapacity. Incapacity is something else. Well, he said, well, okay, well, no. Court said, okay, we might agree, but can you get a doctor to verify that? And they said, don't worry, we have a death certificate. And so they're like, the death certificate will be a doctor verification. But the coroner didn't actually have an MD degree, and so it didn't count. And what was the Missouri statute for it to become effective? One doctor had to determine incapacity. So when I put in my documents, death means incapacity, it's because Missouri law has no clue what it's doing in a practical sense. So should you write your own documents? Don't do that. I'd almost say nothing is better than when you try to do something and Missouri tries to interpret it. Like, it just doesn't work out. So definitely, I'd say level one is, like, go to an attorney, any attorney, let them do it. They went to law school, they can figure it out. Level two is, don't do that. Like, even, like, most of the documents I see, they're not thinking about nursing home. They're not thinking about long term. They're just thinking about, well, how do we pay a bill? And so they're not going to include in there the language that I want. And so I recommend going to what's called an elder law attorney. And I'm a part of an organization called NALA, the National Academy of Elder Law Attorneys. That means someone lives and breathes estate planning. And they're going to um, put their time and their money and their energy into making sure they know these really stupid nuances in the law that you don't find out about unless you're living and breathing it. So it's great. And then the question is specifically, you asked about notary and witness. I do both, even though both are not covered in Missouri, because if I think, what happens if you're going to Florida and you get in a car wreck in Florida and you want to use my document, I want it to be as conservatively drafted to be successful in all 50 states, even though it's designed for Missouri. I go above and beyond so it can hit every state that you may have to hit. Now, if you live in another state, get a state and that's document for that state. But yes, do I have both of them, notarized and witness? Yes. Is it required? No. And I have 2 witnesses, again, trying to meet the most conservative law that's out there. Great question. Yeah. Yes, funeral decisions, who is in handling your body, and it's the right of sepulcher, is in the healthcare power of attorney. And I might be saying that wrong. I'm one of those people who do lots of reading of very big words. And so sepulcher is, though, I think how you say that word. All right, love that. Any other questions? So you'll be glad to know the healthcare power of attorney was the easy one. The financial power of attorney. So if I see people come to me, typically they might actually have that one, but that's fine. Like, that's saying, how do you take care of Jessica's body when she's alive but ill? So Jessica's had a stroke. You can now make medical decisions. What about my money? What about if I have a social security? Because now I'm disabled, so now I'm probably going to get social security disability. What about that money when it comes in? What are you going to do? What about that cell phone that's in my name? What about, yeah. Sometimes people put them into one document, but preference that I like 2 documents because sometimes those are 2 different people. And then there are different legal requirements for them. Healthcare legally has to have a doctor say you are incapacitated. A financial is not the same way. My husband hates doing anything financially. He wants his effective immediately so that I can handle all financial things. Can he still do it? Absolutely. He can still, legally, he can still do it. He just hates doing it. And so I don't know if you are that person in the relationship who, when you try to handle something for somebody else and they're like, can you please put them on the line? And you put them on the line. They're like, tell my spouse, whatever they want to know. And that's it. Well, that phone call, if they can't make that statement, they can't do that verification, the power of attorney is the substitute for that. You give them the power of attorney, and now it's just like you copied your spouse or your significant other or whoever it is. And sometimes it's a good idea for that to be effective immediately. So yes, can it be one document? It can. I have a preference for them to be 2 separate documents. All right, we're going to dive into financial power of attorney. So this one gets a little bit more complex, so I'm actually going to be looking at notes at times because I don't want to miss anything. Okay. There are 2 types of power of attorneys, and we just talked a little bit about this. They're the kind that are immediate, which is functioning right now. So maybe you have a parent that you're like on their bank account, but if you were to go and try to do something with their cell phone, or you were to try to do something with their internet or their electricity, you might have to bring them there. This document lets you be everything for that person, except for 2 programs, and they're federal programs, and that's with the VA, they have their own, and Social Security has their own form too. But every other thing that's regulated by a state agency or by a corporation or a business follows power of attorneys. So anyways, these documents can be 2 forms. They can be immediate, functioning right away, or they can be what we call springing. So we make it right now, we make it today, but we let it sleep. And it's going to be triggered by something. And that trigger is when you become incapacitated, and 1 or 2 doctors determine you're incapacitated. Again, I prefer 1. And then when a doctor puts into writing that you're incapacitated, the document goes from sleeping to functioning. Okay. What are the types of things that you're going to see in a power of attorney? You have the ability to pay bills, to pay a credit card, to hire and fire providers. So accountants, attorneys. So what if you're like, okay, mom really needs to hire an attorney so that she can get her Medicaid in place, or so that we can do XYZ. We want to hire an accountant. You need to be able to sign mom's name there. You don't do illegal forgery. So what's the other alternative? You do mom's name by your name, POA, power of attorney. But you have to have the power of attorney. That's what that document's letting you do. It's letting you go in and do things on behalf of that person. Now, here again, I do nursing home planning, and so when sometimes if you have a loved one and you go and sign them in, they'll have like on the form, it'll be like the person, and then you could sign as power of attorney, and then they have another lovely option where like, we'll let you sign as family, and we'll let you take the bill on yourself. That's horrible. Don't do that. Don't do that. Let nursing home bill of your loved one stay their own. What is the better way to take on mom or dad's debt? To have a power of attorney for them that says, yeah, this is mom's nursing home bill, and I'm going to sign it as mom by Jessica, POA. Because then if mom doesn't pay that bill, you're not coming for Jessica's house. I want that separated from me. And so that's an important thing to have, is making sure you're not signing up for somebody else's debt and making it your own. This lets you be able to access emails, anything, pay taxes, give gifts, nominate guardians and conservators. When you're thinking about this process, it's very important to think, who should that be? And who it should be for the healthcare side may not be the same as the financial. And don't just choose your oldest child. This isn't like a birth order decision. This is a decision of who is a person that is great under pressure, that they can be like, yeah, no, I can handle this. Everything's going really hard, and I'm going to get on top of it, and I'm going to be able to handle paying all these bills and making sure everything's done. You also want them to be a diplomat. I generally recommend one person serve at a time. I don't like multiple people serving. One captain of the ship. That's what I like. And then you can have another person listed next if that person can't serve. Make sure that whoever you put in place is a diplomat, because they're going to have a lot of authority. And so we want them to be able to listen to all that are around, but we also want them to have the ability to make that decision. And you might be listening to this and being like, ooh, I am not the agent that should be listed on someone's power of attorney. You're like, I am the middle child, and I will be happily doing that. I'm thinking of my middle child, not he's like, no, thank you. It's my youngest, actually. That would be my, she's the one who, like, she's 7, and I just gave her access to the family calendar on the phone. And so now, like, every morning I hear her talking about what's happening for the day, and which has been a blessing and a curse. Sometimes if I don't want her to go to Girl Scouts, like, I just won't mention that it's happening. But now, like, a week ahead, she'll be like, Thursday, Mom, 6 p.m., it's Girl Scouts. I was like, yep, you will be the agent when I get older. Like, I know it. I see it. Make sure that they communicate effectively. So I talk about this document and how great it is to manage someone's life. It's also the tool that can be used for elder abuse and fraud. Don't give it to the wrong person. I'm very, very particular about when I draft power of attorneys. Do I think they're great? Do I think they help save lives, save finances? Absolutely. Do I think that if you give it to the wrong person, you've just put yourself at risk? Absolutely. So think about it. If you can do it, and I make my power of attorney in a way that they can do it too, if I could sell my house, take all of my investments, go down to Vegas and put it on red, so can they. Don't choose somebody who would do that. Choose somebody who is very smart and will do wise things with your money and take care of you. But know that if you chose the wrong person, they can also take advantage of you. So make sure you have a right person. If you don't have this document in place, what's going to happen is you're going to hit a roadblock. If they have a condition where they can't share, they have Parkinson's, they have dementia, whatever it may be, there's 100 different conditions out there that may stop them from being able to manage their own finances. You're going to hit a roadblock, and then you're done. And what's the alternative? Back to that court to ask permission to pay a bill. And when the court appoints you, because they don't want the job, they're going to appoint somebody to do that job. They want you to ask them permission for everything you're going to do. So there's an example that I have. I mean, there's thousands of examples. In a power of attorney, if it's drafted right, I put in my documents, I would give someone the authority to make gifts. What does that mean? Mom has a history of taking everybody out for Christmas dinner once a year, right? That's what she wants to do. That's a gift. Power of attorney is a good one, and it's in place, and I'm my mom's agent. I can still do that, and mom still gets the joy of it. She may have dementia, but being at that family dinner and knowing this is what we've done for the past 20 years, she can appreciate that she did this for us all. I've been in court where I've asked for that same permission. Can we go and do a birthday dinner and have the person cover it? And the answer was no. That's a bad use of their money. It's their money, but we had to ask the court for permission, and the courts then up to the judge of what they want to do. That's not what I want someone's life to be like. Not if they can choose somebody who they would trust to make that decision instead. You don't know what judge is going to be appointed. All right. I'm going to go into some pretty advanced topics real quick for the financial power of attorney, unless we have some questions about what this is. What is this document? What does it do? Do you guys have any questions so far? Yeah. I mentioned VA briefly. What is it? VA is a federal program with federal laws, and it's one of the few things that won't recognize a state legally binding document. So the VA has their own process if you become incapacitated on how to access VA benefits. Same thing for Social Security. Like if you wanted to change where it was deposited to, that would be through the actual Social Security Administration. They have their own. But when the money goes into the bank account, now it's a state issue. So it's just literally, if you were to go knock on the door of the Social Security office and say, I want to change something about what you're doing, they would say, we don't recognize you. We have our own process. So, but then when the money goes into a bank account, now we're at the power of attorney phase. Great question. Power of attorneys are living people documents only. They are not death documents. When you die, that power of attorney disappears. Now, I said that, and then I also told you it did funeral arrangements. So it went that far into death. It just like puts your body where it needs to go. Nothing more. The bank, no more access to the bank accounts. As soon as you pass away, the authority and the power of attorney passes away. What a brilliant question. I love that. Good job. Yeah. Oh, common sense, right? Like you've been doing it for years and you think that I still can. Nope. It ended automatically. Then you do something different. Exactly. Exactly. All right. So you're doing wonderful. I hope you're tracking because I know it's complex. Now you're thinking, I need to get a power of attorney, or you're thinking, oh, thank goodness I already have one. But my question is, do you actually have a good one? Not all power of attorneys are set up the same. So this makes sense under law. I know why they did it, but I also know it's stupid in how it turns out. Uh, I'm sure there's a better, more eloquent phrase than I could use than that. But Self-dealing is banned under law. Let me tell you what self-dealing is. Let's say you want to make a power of attorney, and you're like, man, Jessica was amazing. I'm going to make Jessica my power of attorney. And so you make me your power of attorney. Well, under law, I have to keep your things separate from mine, and I have to do bookkeeping when I spend things, and I have to keep track of everything. And I'm not allowed to benefit from your money. That's the default law. Now, let's be practical, though. You're not going to choose me, and I'm not going to accept to be your agent. That's a lot of work. You're going to choose your spouse. You're going to choose your son, your daughter. You're going to choose some loved one to be your agent. And you probably do want them to benefit from this transaction. So, for instance, my husband goes into our bank account and gets the disability payment that I'm getting because now I have a stroke. So he's going to get that payment. Guess what? I want him to use that money to buy himself food. But if it was Jessica Attorney is your agent, I'm like, yeah, let's go use Jane Doe's money to go buy me McDonald's. No, that's illegal. But the law doesn't know that difference. And so the law says it's banned, and that's why my documents say, we're going to let you self-deal, spouse, child, because we know that even if you're not in the home, spouse probably wanted you to have electricity and probably was okay with using spouse's social security to pay for it. And it's just not a way that we think if you're not living and breathing estate planning and elder law. You don't think about those things. So I allow things like self-dealing. I allow for you to provide for your spouse or for your children. I also allow for what's called comprehensive Medicaid planning or long-term care planning. And we'll talk about this later. We have a lot of options under law of how, if you need help in the home or you are going to a nursing home, how can we protect assets? There's just so many options that are out there. But if you don't have a good power of attorney, all those options, the door's shut. And the only way to open them back up is to go to the court. And now I have to be like, hey, court, I know you didn't want to pay for a birthday dinner, but can I just give the farm to the kids? Like, really, if the parent had the choice of like the nursing home getting it or the kids getting it, and I can do that, I think they'd rather have the kids get it. And the court can say, no, it's going to the nursing home. And that's not made up. Like, that is literally a situation I had. I tried to explain, court, please, we can protect this house without a problem and have it go to the kids. And the response was, we would rather it go to their debts. And we will let them spend it, make them sell the property, and then make them spend it on the nursing home. Because that's the court default. I would rather it go to their debts than their children. If this person had had a power of attorney, wouldn't have happened. We could have saved the property. Wouldn't have been a problem. You have to have the right tools in place. Because if you have to go to a court and you have to ask permission to do things, you're at the mercy of that court. Now, that being said, I don't want to like bash all courts because I mean there are so many that I go to that I ask that same request and they're like, of course, birthday parties are fine. And there's so many that are like, please save the family farm. That's exactly what they want. Like, so I've been at courts that have done that, but I've been at courts that haven't. And I don't like it to rest on what jurisdiction you're in and what mood the judge is in to make those kind of decisions. All right. That's your crash course to power of attorneys. Any question on what those are and why you need one? Yes. Any other questions? Mm-hmm. So you just make a new power of attorney document. You'd reach out to an attorney and you'd say, I would like to make an appointment and make a new power of attorney document. And then you can you can get rid of your old ones essentially. So there's ways to, like in my documents when I make them, I say we are voiding previous documents. And so it just kind of gets rid of those. You want to make sure they're not in circulation. So if you have it at the bank, you go to the bank and say, hey, here's the new one. And then you give them the new one. Yeah. Where are they found? So I actually don't recommend filing them because I don't think it's anybody's business what they say, because there's a lot of private information about your preferences on there. Now, we may need to file it at some point, but only if we go to sell real estate. So if we're not selling the real estate, we just keep it. When I do estate planning, you get a black binder. And so we just keep it in the black binder. And then if we go to sell real estate, then we'll go and record it at the recorder of deeds when we do the transaction to sell the property. But honestly, that doesn't happen too frequently, and so a lot of times nobody will end up seeing that document. So the question was, what's a proof of how does it work? So let's say in the situation with my husband where it's immediate, I'm dealing with, he's got a pharmacy that we deal with to order things. And my financial ones even have a HIPAA release, so it still lets me handle medical information, but it's more the billing side that I'm doing. So I would give this to the pharmacy, and I would say, here's a copy of the power of attorney. Please keep it on file. And then when I call the pharmacy, I'll say, this is Jessica Rooks, power of attorney for Aaron Rooks. You have it on file. I would like to refill his prescription. Done. And so each institution will have a copy of it if it's active. All right. Oh, yes. So the question was, are they going to accept that? How are they going to know that it's valid? So there is a provision in the document that says this is a valid document. Copies are at least in mine, it says copies are as valid as the original. The person who's reading this and using it, the institution, is allowed to rely on it, and they will not be legally in trouble. And then I go on to say, and if you don't, you will be, because we have a document that's binding. Now, if you have someone that decides to commit fraud, that's just like them stealing your checkbook and writing checks, bad checks. Like, people can do all sorts of illegal things. That's not the financial institution's fault. That's their criminal activity. So if someone's like out forging things, which is, honestly, that's why I go back to saying don't sign your parents' name. That's illegal. Like, that's the forgery we're talking about. So make sure you actually do have a document that lets you legally do what you might feel like you've been doing anyways. You're like, okay, maybe I did write mom and dad's name on their checks because it was hard for them to do. Yes. Yes, the document's notarized, witnessed by two people. Can you forge all that? Yes, but again, shame on the illegal person doing the illegal activity. But yeah, it'll be notarized and witnessed. Good questions, guys. All right. All right, these were your life documents. These were documents you needed when you were alive. Now, we're going to talk about what happens if you're dead. So that's the next phase. So forget everything you know. This was just living documents. Yes, thank you. It is the transit. I'm like, do we need donuts? Do we need to take like a 5-minute break before and let's do that. Get drinks, go to the bathroom. We'll come back in 5 minutes and we'll do donut. We'll have a donut break. Oh, no. maybe. Okay, I'm on now. There are business cards and pins in the back if anybody would like them. I always forget to tell people that. We'll have you guys start heading towards your seats. We're going to begin the next phase of life. Wonderful. Guys, thank you so much. I feel like so welcomed, and I really like sharing this information. You know, big picture, I don't expect you guys to retain this. I just like the opportunity for you to hear it, especially if you've never heard it before. It's one of those areas that it's got so much misinformation that just a chance to kind of hear some of this is really important. Um, one thing that I would like to, as we're kind of going into this and we're talking about the next phase, whether it's the healthcare power of attorneys, the financial power of attorneys, or we're talking about what happens at death, my general thought process is communication is key. So make sure whoever you choose for these things to do these jobs, that they know that they're having them. If they're the healthcare power of attorney, make sure you tell your agent all of your healthcare preferences. Make sure they know that they're your agent. Make sure they know that they're your financial person. And then as we talk about passing, everybody, yes, you can keep this secret. And you know exactly what is best for you and your family. That is up to you guys. But if you were to ask my personal, non lawyer opinion, if you're going to do something, one, let them know. It's easier to manage when things aren't secret. And two, if you're going to make somebody angry, please make them angry when you can talk to them and tell them why you did it. Don't be like, surprise, I'm dead and I'm making you really mad. What that turns into is lawsuits. And then we end up having family conflict, and we have people that will never restore their relationships because they are grieving and they're going to do things they would never typically do. So, you're going to do something that you think may not set well, let them know. And then they can be mad at you instead of their sibling or their loved one. And they can process that while you're alive and here and let you know what they're feeling. And then they can still deal with the outcome, but it will have a chance of being more successful. So, with that being exciting little caveat starting, let's go into what happens when we pass away. The number one thing that we want to do is we want to avoid probate. What is probate? Why are we working so hard to avoid it? Probate is the way that probate property goes from the deceased to the living. Probate property is property that when you die, you don't know where it goes. So let's talk a little bit more about examples and what that looks like. Let's say you guys came here today in a car. And it's okay if you don't know these answers, but it is a sign that you probably need to get your estate plan in order. Let's say you drove here today in a car. Think back to that title. How is it owned? And you're going to say, I own it as wife. Okay, all right. And it has TOD to husband. Okay, good. If I pass away, where does it go? It goes to my husband. Does it go to probate? No. Why? Because I showed you a title and it said exactly where it went. Husband and I, let me put the little caveat out here. We are having a socially inappropriate conversation today. We are going to be talking about death and we're going to be talking about money. And so in these scenarios, my husband and I will be dying in a variety of ways and it will be very tragic. And I apologize that that is not socially acceptable. But back to the car title. I own it, TOD to my husband. And we both died in a car wreck. Where does that vehicle go now? Probate. I loved it. Thank you. Thank you. That's the answer. Why? Because that document doesn't have an answer of where it goes next. So I want to have as many ways to avoid probate as possible. So a great way for me to own that car, if we're looking at a basic plan, and I'll tell you the philosophy in my office, 90% of all people just need a basic plan that avoids probate and is well written with power of attorneys. We can do more complex in our office, absolutely. But if we're going to do more complex, I want you to know why we're doing more complex, and I want to know why we're doing more complex, because if we can meet your needs basic, let's stay with basic. And if we need to go more complex, great, we can do that, but let's have a reason. Okay, back to what would be a basic way in a very traditional family of how I could avoid probate. Husband and wife own it together with a TOD, transfer on death to, this will be one of those only reasons, if I and I have 3 kids, that I would only put one. And in this scenario, because we're trying to stick basic, my 3 kids are going to be adults. And so I would let it go to Dylan, but I would tell him, Dylan, I don't love you more than Ryan and Libby. I just don't want all 3 of you to go to the DMV and have to get this car titled in the name of 3 people. So I just chose one of you to get it. Not because and then I'm going to tell Ryan and Libby, Dylan's getting the car, here's why. So anytime we do something unequal that doesn't seem quite fair, I let somebody know why we're doing it. Title items tend to be where that would, title items with the DMV would be where that is. And you're like, okay, well, what do I do? You're going to go to the DMV if you don't have it updated the way you want it to be. You're going to pay your $14 to do a title change, and you're going to add your owners and add your TODs. And you're going to say, I'm not doing that for the vehicle in the back 40. Please do it for the vehicle in the back 40. You know how much probate is like awful? Probate is awful when you're going there to get money. Probate's even worse when you're going there for the vehicle from the back 40 because you can't take it to the scrapyard because you're not the legal owner. And now you have to go have probate on the piece of vehicle that doesn't even function. Please go to the DMV and add TODs. That's really important. So, vehicles. That's one thing that we own. What else do we own? We own cash. Let's talk about that. Bank account. And before I quite get to bank account, I am not a basic plan because I have children under the age of 18. And so if I were to give something to my children, there's special language. I can still give it to them, but there's custodianship language that I would want to use that would say, give it to Dylan, but I want Jane Doe to take care of it until Dylan's 21. So, and that's just it's a liner. And again, if you're with my office and we're doing this, then I give you the language to give to your bank or to take to the DMV to put on that title so that it doesn't go directly to Dylan. If Dylan were to get $10,000, so Dylan's my oldest son, he's 12. If Dylan were to inherit more than $10,000, do you know what happens to that money? It's our favorite place, the courtroom. The court is going to manage that money that went to Dylan, and they're going to decide what to spend it on. And so if I say, if whoever's raising Dylan, or let's just say his dad's raising him, but on my bank account, it was just in my name and I didn't do good planning, Dylan's going to inherit some of that bank account. It doesn't all go to my spouse if I didn't put a plan in place. And so then we're going to be in court and we're going to have to ask permission on how to spend that money. That's horrible. But if we have the right language that we can put as a beneficiary, we can choose who would manage that for my son. That's a lot of information. Let me go back through it one more time. Beneficiaries are amazing. If you have adult children, that's really, really simple, especially if they're good with money. Just put your adult child as a beneficiary. Let's say you have a minor child. There's special rules out there and wording. Still can be simple, but you don't want to just put a minor child as a beneficiary. More things that we could talk about as we went more in depth one-on-one. So we've talked about vehicles. How do we avoid probate? TODs, DMV. Money. Money is held at a bunch of different places. Every place where your money is held, you need to make sure it has a beneficiary. So let's talk about the bank. Bank is held, bank account, my husband and I have a checking account. Husband, wife. If I die, goes to him. If he dies, goes to me. Very simple. If we both die in a car wreck, what happens? Well, if I didn't put beneficiary designations on there, where's it go? Probate. If I did put beneficiary designations on there, it goes to whoever is listed. So one of the things when you come to my office, I say, I'm going to have you a black binder, and then you're going to work on some homework, and part of that homework that you're going to go out and work on is making sure that everything has beneficiary designations. And what I encourage people to do is as you're out there gathering that information, take one bank statement and the proof of beneficiaries and put it in a folder. And then from your note card, say, this important folder is located here. So having someone know where to find information is key. And that goes back to our first part of the discussion, is just being able to find the things that we're talking about. So bank accounts, let's talk about investments. These would be stocks, things that would maybe be with if you had like an Edward Jones guy or an investment guy, whatever it is that you're going with, you would go to them and say, who owns this account and who are the beneficiaries? Typically, if you have a financial investor you work with, they're pretty good at making sure you have beneficiaries listed. So that's exciting. If you have 3 kids, let's not just put one down. Unless you have like a reason why we're thinking about doing that. But if you're like, I don't know, I just chose a child. Like if there's no reason, you actually want all 3 to get it, put all 3 kids down. And then what happens when you die? Your children are gonna go to the Edward Jones person or to the bank. They're gonna fill out a form, and then they're gonna get a check. That's the ideal way to do it. Thinking of your Edward Jones, you have IRAs. IRAs are typically only owned by one person. And so that would be, let's say wife owns it. Make sure the first or primary beneficiary is spouse, and secondary beneficiary is children. All of these ways are kind of belt strap and suspenders of how we're going to avoid probate. So you're going through and making sure everything has beneficiaries on it. Let me pause for just a second. Any questions? Yes. So the question was, if I own it in my name and it's transferred on death to my spouse, is there a way to get it like a second one? DMV really just allows you to put like one in there. You might be able to ask them, but typically the way to avoid that would be husband and wife own it together and then put a TOD there. Now we've got an extra one going. And I know that's not a problem at the DMV. And I'll tell you, typically doing things tricky at the DMV gets a little bit more complex. Missouri doesn't have like and or wording. Missouri, like if you go and tell them you're owning something as husband and wife, when I say husband and wife has special legal protection. So when you guys go and say we are husband and wife and owning this item, it then inherently protects it to go from husband and wife to husband. Yeah. Yeah, adding other owners may get a little tricky if you have debt on the asset. All right, good questions. I know. Now we're getting into like this is the things that you could literally run out the door and start doing, and these are really good things to make sure are in place. Um, okay, some people, and I'm just going to throw this bomb out there, and I'm going to walk away from it. Some people have husband, wife as owner, and then their beneficiary is a trust. So you could put your kids directly, or you could put a trust. And we're going to talk about trust later. That's why we're just walking away. But it all avoids probate. It doesn't matter if I put husband, wife, and children, or husband, wife, then to trust. When you look at the document, it says where it goes, and it all avoids probate. Same thing. What is the difference? When I give it directly to the kids, they get their check from the bank, they get their item, and they're gone with it. When it goes to a trust, they walk to an attorney and say, Mom and Dad are dead. We're ready to follow the rules of the trust. And then the trustee, who is in charge of the trust, manages it. Now, walking away. Back to other items that we may own. Land. This one's really common. If you own it as husband and wife, husband dies, goes to wife, wife dies, it goes to husband. If you own it as husband and wife and his spouse dies, there's nothing you have to do. It just automatically goes to the other spouse if you guys own it as husband and wife. So there's no going to the title company and having to update it. You can, like you could update your title and change it at the recorder of deeds and things, and you could let the tax assessor know my spouse has passed. But legally speaking, it instantly happened. And now you can also add a beneficiary deed to your land. And the beneficiary deed is the document you look at that says where the land will go if you pass. So, husband and wife, if you own it together, husband dies, it goes to wife, wife dies, it goes to husband. If you both die, you can add a beneficiary deed and have it go to the children. And that will include anything physically attached to the land. So if you have a mobile home that has a title, the title will be what transfers it. But if you have a stick-built home that is attached to the land or a barn attached to the land, that deed controls house and barn and things that are attached. In Missouri. Yeah, I'm only giving Missouri legal advice. Yes, only Missouri. Good question. Now, beneficiary deeds avoid probate. Beneficiary deeds do not provide nursing home protection. It is important to know that we are talking about avoiding probate, not nursing home planning right now. And some people think, I'm just going to add the kids so it's husband, wife, and my 3 kids now own the farm with me. It's protected from Medicaid. No, it is not. That's not doing what you think it's doing. So there's so much misinformation out there, so much malpractice. I want you to just I want to clear up a little bit of those. Just kind of throw that out there. So land can have a beneficiary deed. Cars can have a title. Then we have what's called a deed of gift. Most people do not have this. About the only way you're going to get it is if you go to an attorney's office. And this is going to say, all of my personal property that does not have a title on it, upon my death or our death, husband and wife's death, we want it to go to, and then we can put the 3 kids' names. We're going to give it to the 3 kids. Now that means those 3 kids own that property, and this will be your tractors, your livestock, these are your mowers, your anything that doesn't have a title on it. That's what that deed of gift is handling. And so if you pass away, you and your husband pass away, and the kids are saying it's time to have an auction, and the auctioneer says, do you own anything here? The proof of ownership would be deed of gift, death certificate. This is why I'm legally allowed to sell all these things. And then whoever's on that deed of gift is who owns that personal property. And that might be child 1, 2, and 3 now own it. Now, a deed of gift, a basic plan, is only good when you have kids that get along real well. Because if they're going to fight, you just split the fork 3 ways. Each of them owns that fork 1/3, 1/3, 1/3. So if they want to fight over what happens to it, there's so many items in that house and on that farm to argue with. A basic plan is not good for kids who don't get along. That's why we'd go to something more complex, like a trust. That's a good reason for a trust. Other good reasons for a trust. You have a special needs child who is on government benefits and is disabled. That's a great reason for a trust. But we want to know why we're using a trust. Maybe if you have minor children and you want to keep the items in control beyond the age of 21, maybe you want to keep it in the trust until they're 35. That's a trust issue. So there are reasons why we go more complex, but trusts aren't. Sometimes I think they were like kind of, but prior to 2011, there was a lot of reasons why people needed trusts, but there was a significant change in the law in 2011, and trusts don't quite do as much or as needed anymore. So I don't go there automatically. A basic plan of beneficiary designations can go very far for most families who get along. Now, if I talked about the personal property not doing well, the same thing is on real estate. If you have 3 kids and you're going to give them the family farm, that means they need to get along well enough to decide, are we keeping it? Are we selling it? If we're selling it, how much are we selling it for? And if they can't figure those things out, the only resolution is the courtroom. Don't do that. Like, if you don't think they can actually figure it out, then we need to go to a trust, and a trust needs to answer those questions for them. But if you think, you know what, it's not a big deal, like they know what's happening and I'm going to give it to all 3 of them. Now, also, like I said, don't generally give it to just one person, because that's not, if that's not your intention. If your intention was actually to give it to all 3 kids, don't just give it to one. All right. That's a lot. Yeah, let me get some questions. great question. The question was, what happens if somebody passes away in the basic plan? So there's a couple answers. One, the specific question was about a beneficiary deed. And the answer to that would be, it depends on how it's drafted. So sometimes the way, and the law that applies. So sometimes the way it's drafted, that child's share would then go to their children. But it has to, it doesn't, it depends on the legal circumstance. So that would be a maybe. And what about the bank? What about all those places? The drawback of the basic plan is that you need to stay up on top of it. So if people start dying, you need to go back to the bank and you need to update it. You need to come back and see your attorney. If your children predecease you, that's what I call a trigger to come revisit and update things. The basic plan is simple and easy and avoids a lot of extra stuff. But when people start predeceasing you, it means it's time to update the basic plan. You may still do a basic plan, it's just updating it accordingly. If you said, no, I am going to do this one time, I know myself, I'm going to touch it and never come back to it, then do a trust. And a trust can outline what happens in 100 different scenarios if somebody dies and you never want to come back and do it again. That's where the trust comes in. The trust is a rule book where you can say, if person A dies, then I want it to go to B, C, and D, and if they're all dead, then let's give it over here to F, and you get to name all the ways that they get it. So if you want a touch it once and never come back to it, that would be another reason why you might think about doing a trust. Typically, a basic plan, as long as you remember, if one of my kids dies, I need to go update stuff, would work. It doesn't necessarily. Everything is different. So the so it's like TOD would be up to the DMV and what their laws are. The beneficiary deed is going to default to the law of interpreting beneficiary deeds and or the deed itself. So sometimes your deed may have, there's something called, you may have some little letters after the child's name that says LDPS, and that means lineal descendants per stirpes. The long and short of it is every document's different, every situation is different. And so maybe. Good question. Yeah. So I don't, the question was, what about if I just made my kid an owner on everything? That has unintended consequences typically. I generally say, don't do that. I generally say, you stay your owner, and you're like, but I want him to pay the bills. Okay, what tool do we use for that? We want the kids to access our finances, not own it, but be able to do things with it. Power of attorney. So if you want them to pay your bills but not own your things, power of attorney is the tool that you would use instead. So don't necessarily make them the owner. Why are we not making them the owner? If you make them the owner, their creditors are also able to get your stuff. If they get a divorce, guess what? They own your bank account. It's subject to the divorce proceedings. They get into a car accident. It's one of the things that they now own. And if their kids need to go apply for college and they need to make sure their assets are under a certain level, guess what? They may own a lot more than they actually own because you made them owners on things. So ownership isn't the answer. The answer is you and your spouse own your own things. If you need help managing it or you're worried about access when you're not mentally able to, power of attorney is the solution. And if you're saying, how do they access it when I'm gone? Beneficiary designations. Because if both of you are the owner and you both die and there's a beneficiary there, you just take the death certificate to the bank and get the money. That's how you would be able to access it. But yeah, that's a really common misperception is we try to do a power of attorney with kind of like band-aided along, and there tends to be unanticipated consequences with that. Okay. The document is called a deed of gift. It's not actually a gift. It still only applies at death. It's just a confusing name. So yeah, in these scenarios, we're not actually giving anything away. You keep ownership during life, and it's only when you die that it would transfer. They're not paying. It's still yours, 100% yours. And the document itself, that's just what they call it. It's just a horrible name for the document. Yes. Business interest. So if you have an LLC, LLCs need to have their own beneficiary designation, and that might be found in your operating agreement. And my question is, if you have an LLC, do you have an operating agreement? That's a book. That is not, I registered with the Secretary of State. Secretary of State is a registration paperwork. The operating agreement is the rules of what happens to your business and how to manage it. It's not gotten from the Secretary of State. If you don't have that, that is legally required for an LLC to exist. So, what does that mean? If you did that LLC for some form of legal protection so that people couldn't sue you, and the first thing when you go to court they're going to ask is, show me your operating agreement that's required under law to be a valid LLC. And you're like, I don't got one. And they're going to say, well, we don't think your LLC is valid because you're not even following base rule 1. So, operating agreement, if you don't have it and you have an LLC, you might want to get one. In that LLC, in that operating agreement, it might say who your business goes to when you pass away. Honestly, it probably doesn't. And so you need a document that says, when I die, my LLC interest is going to go to my spouse, my children. Because if you don't have a beneficiary on that asset, it's going to probate. And when a business goes to probate, that is a triggering legal event to terminate the business. And you only have a certain amount of time to keep it alive. So don't have your businesses go to probate. Make sure you're avoiding it for them too. Great question. Any other question? Basically, big picture takeaway. You own something, ask yourself, where's the piece of paper that says where it goes when I die? And then put that piece of paper that says where it goes in a folder. And then let your children know where the folder is. So transparency and organization. All right. So your LLC may be owned with 2 people. You may say person A and person B own it. Unless your operating agreement says when person A dies, it goes to person B. When person A dies, it goes to where person A told it to go in their beneficiary LLC beneficiary form. And if you don't have that, it's going to probate. But it can. We could in that form say, give it to my son or give it to my wife. And if that person's not alive, give it to this person. So you can get pretty specific in it, but it does have to exist. All right, so what happens now? We've talked about what makes probate. Probate happens when you don't know where something goes. So we end up in probate. Let's say the LLC doesn't have a beneficiary on it, or the vehicle, both of you passed away and there was no TOD on it. What does it mean to go to probate? It means that asset, for anyone to access it, you have to go to the court and ask permission for it to go to where it needs to go. And the first question the court's going to ask is, where does it go? Can you tell me if you have a will? And a will, the number one misperception people have when they come to me is they say, I want to avoid probate. Let's make a will. Doesn't make sense. Words don't even make sense. A will only tells your probate property where to go. So the first question the court asks when you show up and say, okay, these things, I don't know where they go. Court's going to say, do you have a will? And we'll say, nope. And the court says, well, we're going to guess where you want it to go. We want some to go to the spouse, and then we want some to be split equally between your children. That's where we'll put it. And you're like, no, please don't do that. I want it all to go to my spouse. And then if my spouse is dead, I want it to go to the children. And then the response is, should have made a will. Okay, so that's why we have a will. A will, in my office, when I make one, is a document I hope we never use, because I hope you've done beneficiary designations on everything. But if we forget something, which we're human, it happens, then I want to have a will so that I can tell the court where to put those items. Do I want to use the will? No, because I don't want to be in probate. But if I'm there, I really want to control what the process looks like. That's what a will is. Why is probate so bad? Probate is awful because the attorney makes a lot of money. That's why. Your whatever goes to probate, the attorney gets a chunk of. That we don't want it to go to probate. And then the other thing is, it takes a long time. There was this case, I think it's wrapped up. Yeah, I think it finally wrapped up. I watched it, had minor children, and it took 10 years to complete. 10 years before the kids were able to access it. By the time the kids accessed it, they weren't children anymore. They were legal adults. But the court is just slow. They're not necessarily interested in getting you your money, and it takes its sweet time to get to you. Legally, if you have more than $40,000 in assets, which farm, car, house, things like that can quickly go over 40,000. If you have over 40,000, legally, you can't do probate in under 6 months. So there is just a natural design of being slow. Avoid probate. How do you avoid probate? Beneficiary designations. When do you need a trust? We're going to talk about those things. You need a trust. So there's a whole variety of reasons of why you might need a trust, but we'll go through the most prominent reasons why you need a trust. There are two types of trusts that exist. There is a revocable kind of trust, and that means you can change it, and an irrevocable kind of trust, which means you can't change it. So the types of trusts that you can change, why would you want them? So if I have a bank account and the options are give it to my 3 kids outright or give it to a trust, why am I going to give it to a trust? If I give it to the trust, my child or whoever I put as trustee is going to walk down to Jessica's office and say, can I hire you to administer this trust? It's another bite at the attorney apple. It costs more. It's more steps. It would be so much easier for my kids just to go to the bank and say, can I get my check, please? Done. No need for an attorney to get involved. Basic plan is better. But if we're going to do the trust, why did we do it? Why are we bringing it in? Sometimes we have a child that is disabled and getting government benefits. And if that child gets a direct check, it's going to kick them off their government benefits. That's why we want a trust if you have a disabled child. Sometimes if you give 3 children the family farm, you won't have very nice children. They're going to cannibalize each other. We want a trust that has rules of how to handle that situation. That's a great reason for a trust. You have military grade weapons that you had to ask the federal government to possess. That's a great reason for a trust. That's called a gun trust. You have over $2 million and you want to figure out the best way to avoid taxes. That might be a good reason to look into just different ways that we can work the tax system and with different rules that exist. You have a blended family and you say, I would like my second spouse to live in the house, but ultimately I want the children to get it. That's a great reason for a trust. You would say, I want my kids to enjoy the land while they're alive, but I don't actually want them to get it. I want it to go to my grandchildren. Or I don't want anybody to get it. I want it to stay in trust for years and years and years. Those are great reasons for a trust. Those are the reasons that we work through. The other thing that a lot of people say that they have a trust for is because they want to avoid the nursing home bills that come with it. I will tell you, I do hundreds of Medicaid applications, and what that means is I see a lot of trust. And this is an area where geographically, the trusts that have been created by people did not age well or were not created well in the first place. And so if you have a loved one or you are a person that has an irrevocable trust, that's the first sign. It has to say irrevocable. If it says revocable at the top, it's not a Medicaid protection trust. It's not protecting from the nursing home. So a lot of people think they have a asset protection trust from nursing homes when they don't. So irrevocable, and if you haven't had it looked at by an attorney recently, do that. And when you have the attorney looking at it, ask that attorney, how many Medicaid applications a year do you do? And how successful is this trust at going through that? And let them tell you how successful it's been. Because what I see is a lot of documents that don't actually make it through Medicaid.
And so that means what happens is that I have families come in that have had an item in trust for 20 years that they think is protecting the family farm, and the answer is it's not. Medicaid does not care if you own it as husband and wife or you own it as husband and wife revocable trust. They don't care about that distinction. It's still husband and wife. And so we have to make sure that in order for Medicaid not to care about it, for the nursing homes not to get it, it has to say very specific things. So I'm going to kind of leave that there to let you know that there is things that you can do if you have 5 years before you need nursing home care. There is estate planning that you can do to help protect that asset. Don't assume that you actually have that protection. Make sure it's been checked that you do. I'm going to cover one last piece, and it's going to be the nursing home piece a little bit more in depth. We have 3 ways to cover a nursing home expense. And I say nursing home, it could also be getting help in the home, but we're going to talk about nursing home because that tends to be the most expensive way. We are in the most economically depressed area of the state. Our nursing homes are as cheap as they come. Does anybody know how much a nursing home is per month? 50, ding, ding, ding. And that is so cheap. If you just like make your way to Columbia, it's like 10 or 12,000 a month. So just even slightly getting out of our economically depressed area really affects that bill. $5,500 a month means that in order for you to afford that, your income has to be so high that you're like, yeah, I'd love to pay $6,000 a month for a nursing home stay. And if you end up in a nursing home stay and it's going to be long term, the average stay is 2 years. And so then the question is, how are we going to afford that? 97% of all people, so the first avenue is I just make a ton of money every month and I can afford it. The second route is I have long-term care insurance. If you haven't looked into it, look into it. A lot of people can't do it because it's very expensive and it's not really as available anymore. The market significantly changed because it happened in the past where people got on insurance and then really did not financially work out for the insurance companies to win with. And so now they charge a lot for it. The third option, 97% of all people are going to find themselves on Medicaid. And so if you did not do the 5-year pre-plan, and there's so many reasons why maybe you didn't, let's say you didn't do it, and now you find yourself needing nursing home care, there are so many legal options available to you. That is what my office does. It's called crisis planning. And a lot of times when people find themselves in that situation, the common knowledge that exists is there are no options, spend your money until you have none, and then go on Medicaid. Or my favorite one, there's this, don't worry, your house is exempt. Your farm is exempt. When Medicaid says something is exempt, they just mean during your life. When you die, they're coming after it. So that's not actually protected. So you want to make sure that before you get any government benefits, that you're actually putting a plan into place to protect those assets. So the last thing that I leave you with is if you have a loved one who immediately needs care. So Jessica had a stroke. No, I did not give all my stuff away within the past 5 years. My husband knows there are so many Medicaid planning options that are available right now, even though I did nothing. You just have to explore them. I say that. We're not putting anything over on the government. Everything has a drawback, but I guarantee no plan and no path forward that's organized with knowing the law that's out there is going to be your worst one. You'll end up spending more and wasting more money than if you had a plan. So everything has a drawback. We're not hiding anything from the government, but no plan is definitely the government's favorite plan. Then they get all of the assets. So much information that I covered. And I was wondering, I'm like, do you think I'm really going to be able to talk for an hour and a half on life and death, power of attorney? Yes, that was the answer. Yes. I so appreciate it. Do we have any questions that anybody has? Yeah. You know, here's the thing. Do I have business cards? That's such a good question. I drove up here and I did not have business cards. And my office manager, her sister, calls me and says, hey, don't forget to take pins and office cards. And I was like, oh, come on. We know that did not happen. And she's in the back now because she brought them. So They are on the back table. There are pins and office cards. So, yes.
And there are extra copies of this back there too.
And
note cards.
yes, I will be up here. Anybody, you're welcome to chat with me. I know I appreciate the openness and letting me be here to share things. Like I said, it's all overwhelming. I know that. I just want you to come out with the opportunity to have heard something about a topic that's really hard to understand. So, thank you all. I greatly appreciate it.
And thank you for coming up and being willing to share this with us. She donated her time to do this today, and we really appreciate it. Like I said, cards and pens are back there, like she mentioned, and there are extra copies of this, and I do have it in digital form. If you think that's something you'd like, just let me know. Yes. I think it's on the card. It's in yeah. The address is on the card, and those are back in the back, and she's in Kirksville. Yep. All right. Thank you guys. There's plenty of snacks and coffee if you need a little bit more, and have a great day.